Step away from that desk. You're not authorized to be in here.
This is the attorney prep room. I'm counsel on the 9 a.m. docket.
You don't look like an attorney.
My bar card's on my jacket. Check the docket. Courtroom 402.
I need to verify. People lie.
Verify them, but stop profiling me while I prepare for court.
Officer Derek Miller had been working courthouse security in Chicago for 15 years. The last 10 were spent stationed at the George N. Leighton Criminal Court Building on California Avenue. He'd accumulated 19 complaints in those 10 years, 19 separate incidents where Black attorneys, Latino public defenders, and Asian legal aid lawyers were stopped, questioned, and accused of being in restricted areas when they were simply doing their jobs. Every complaint had been dismissed as a communication issue. The court administration called him dedicated. His supervisor called him vigilant. No one called him what he was, a gatekeeper who couldn't imagine that lawyers came in colors other than white. On a Tuesday morning on the west side of Chicago, everything about Derek Miller's protected position unraveled completely. I had just arrived at the courthouse to argue a critical pre-trial motion that could determine whether my client spent the next decade in prison or walked free. My name is Marcus Thorne. I am a criminal defense attorney with my own practice, 14 years of experience, and a reputation for meticulous preparation and courtroom skill. I'd won acquittals in cases other lawyers wouldn't touch. I'd argued before the Illinois Appellate Court. I'd been quoted in the Chicago Tribune about criminal justice reform. That morning, I was a black man in my early 40s, wearing a charcoal suit, carrying a leather briefcase, reviewing my case files at a desk in the attorney preparation room. And to Officer Derek Miller, that only meant one thing: I didn't belong there. That false assumption triggered a confrontation that would end in Miller's termination, a formal complaint to the Illinois State Bar Association, and a $4.5 million lawsuit that would expose the systemic bias embedded in courthouse security. Before I continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these need to be shared, and your support helps us bring more truth to light. Chicago, the Criminal Court Building at 26th and California. A massive limestone fortress where the machinery of criminal law ground through hundreds of cases every day. Preliminary hearings, arraignments, motions, trials. The building housed courtrooms holding cells, prosecutor offices, and attorney preparation rooms where lawyers reviewed evidence and prepared for arguments. The attorney prep room on the 4th floor was a small space with 4 desks, filing cabinets, and a copy machine. It was designated specifically for attorneys to use before court appearances. A sign on the door said, "Attorney workroom authorized personnel only." I had arrived at 8:20 a.m., 40 minutes before my scheduled motion hearing. I needed the time. The case was complex. My client, a 22-year-old named Dante, was facing armed robbery charges based on eyewitness identification that I believed was fundamentally flawed. Cross-racial identification, poor lighting conditions suggested photo array procedures. I had filed a motion to suppress the identification evidence. If I won, the prosecution's case collapsed. If I lost, my client was looking at 10 to 15 years. I was 44 years old. I'd grown up on the south side of Chicago, watched too many people I knew get swallowed by the criminal justice system, and decided I wanted to be the person who fought back. I'd worked my way through Northwestern University, then Northwestern Law, graduating near the top of my class. I'd spent 4 years as a public defender before opening my own practice. I took cases other attorneys avoided: the unpopular defendants, the complicated facts, the clients who couldn't afford the big loop firms but deserved someone who'd fight. I'd set my briefcase on one of the desks in the attorney prep room and spread out my files, police reports, witness statements, photo arrays, expert reports on eyewitness identification reliability. I was making notes in the margins, cross-referencing Illinois case law, preparing my argument. My bar card was clipped to my suit pocket visible. My name was on the court calendar, posted outside every courtroom. I belonged exactly where I was. Officer Derek Miller was making his rounds on the 4th floor when he walked past the attorney prep room. He glanced through the door's window and saw me at the desk, surrounded by files, and his brain made an instant calculation. Black man going through files. Probably not supposed to be there. Probably a defendant who wandered into the wrong room, or maybe someone trying to access confidential information. Definitely not an attorney. Attorneys don't look like that. Miller opened the door and stepped inside, his hand resting on his belt near his radio. "Sir, step away from that desk. You can't just go through people's files." I looked up from my notes. I'd been so focused on my preparation that the interruption took a moment to register. Then, I saw the courthouse security officer, saw the suspicion on his face, and understood immediately what was happening. I'd experienced versions of this before. Not often, but enough to recognize the pattern. "These aren't people's files," I said, keeping my voice calm and professional. "They're my case notes." Miller stepped closer, his eyes scanning the documents spread across the desk. "Case notes in a courthouse? You a clerk or something?" There it was, the assumption, the automatic dismissal of the possibility that I could be an attorney. The casual suggestion that I must be support staff, administrative, anything other than a lawyer preparing to argue before a judge. I felt the familiar mix of frustration and weary recognition. "No, I am here to argue the motion in courtroom 402. Miller's expression shifted from suspicion to disbelief. "Hold on. You're saying you're an attorney?" "That's exactly what I'm saying." I gestured to the bar card, clipped to my pocket. "My name is Marcus Thorne. I'm a criminal defense attorney. This is the attorney preparation room. I have a motion hearing in 35 minutes. Everything I'm doing is exactly what I'm supposed to be doing." Miller looked at the bar card, but his skepticism didn't fade. "Doesn't seem like it." The words hung in the air. 3 words that said everything. Not based on evidence, not based on credentials, just a feeling, an assumption, a gut reaction that this black man couldn't possibly be an attorney. I set down my pen and stood up, my full attention now on Miller. "And yet here I am, the defense attorney you just assumed couldn't be one. Do you think courthouse officers should verify credentials before questioning attorneys? Drop your answer below." Miller's face hardened. "Look, I don't know who you think you are, but I need to verify this. You could have stolen that bar card. People try all kinds of things in courthouses." My patience was running thin. "Officer, look at my bar card. Marcus Thorne, Illinois Bar, number 620481. You can verify it with the State Bar website right now. You can check the court calendar posted outside courtroom 402. You can call the clerk's office. My name is on the docket. I'm listed as defense counsel for People vs. Dante Williams, scheduled for 9 a.m. I have every right to be in this room preparing my case." Miller pulled out his radio. "I'm going to need to call this in." "Call what in? I've identified myself. I've shown you my credentials. I've told you exactly why I'm here. What policy am I violating?" "You're acting defensive." "I'm acting like an attorney who's being profiled while trying to prepare for a hearing that could determine whether my client spends the next decade in prison. There's a difference." Another courthouse security officer appeared at the door, drawn by Miller's radio call. Officer Sarah Jenkins had been working courthouse security for 7 years and had a reputation for common sense and de-escalation. "What's going on?" Miller gestured toward me. "This individual claims to be an attorney, but I'm not convinced. Says he's preparing for a hearing." Jenkins looked at me, then at the files spread across the desk, then at the bar card on my suit pocket. She walked closer and read the card. Marcus Thorne, Illinois State Bar Association. She pulled out her phone and opened the State Bar website, typed in the bar number. The result came back immediately. Active attorney, good standing, admitted 2011, no disciplinary actions. She looked at Miller, her voice flat. He is an attorney. That's a legitimate bar card. And this is the attorney prep room, where attorneys are supposed to be. Miller's face flushed. I was just verifying. No, you were assuming. Jenkins turned to me. Attorney Thorne, I apologize for the interruption. You have every right to be here. I nodded, but my expression was hard. This isn't the first time this has happened. Not just to me. I've heard from other black attorneys in this building who've been stopped, questioned, mistaken for defendants, asked to prove they're really lawyers, and it's always by the same officer. I looked directly at Miller. You saw a black man with files and immediately assumed I was doing something wrong. You didn't ask for my credentials first. You didn't check the sign on the door that says attorney workroom. You didn't consider that I might actually belong here. You led with suspicion and accusation. Miller opened his mouth to respond, but Jenkins cut him off. Officer Miller, return to your post. I'll handle this. Miller hesitated, then walked out, his pride wounded, but his bias intact. Jenkins stayed behind. Mr. Thorne, I want you to know this will be reported. What happened here is unacceptable. I appreciate that, but reporting isn't enough. I want to know how many other attorneys have been stopped by Officer Miller. I want to see his complaint record, because I guarantee this isn't an isolated incident. Jenkins nodded slowly. I've heard things, complaints, patterns, but they always get dismissed as misunderstandings. That's the problem. It's not a misunderstanding when it keeps happening. It's profiling, and I'm going to document it. I checked my watch. I had 25 minutes before my hearing. I couldn't let this derail my preparation. I sat back down at the desk and returned to my notes, but the interruption had broken my focus. The rage was simmering beneath my professional composure. By the time I walked into courtroom 402, I pushed the encounter into a compartment I could deal with later. Right now, my client needed me. The hearing lasted 90 minutes. I presented my motion with precision and passion, citing case law, challenging the reliability of the identification, demonstrating the constitutional violations. The judge took it under advisement, but signaled he was leaning towards suppression. I had done my job well. After the hearing, I went directly to the court administrator's office. I filed a formal complaint against Officer Derek Miller, racial profiling, harassment of an attorney while performing professional duties, creating a hostile work environment. I requested Miller's full complaint history. Initially, the administrator resisted. That's personnel information. We can't just release it. My voice was steel. I'm an attorney who was profiled while preparing for a court appearance. I have a right to know if there's a pattern. And if you don't provide it voluntarily, I'll file a Freedom of Information Act request, and then I'll file a lawsuit that will make this a public record anyway. The administrator looked at me for a long moment, then pulled the file. 19 complaints. 18 of them involved attorneys of color being stopped, questioned, or accused of being in unauthorized areas. All dismissed. All marked as communication issues or misunderstandings. I photographed every page. This isn't a communication issue. This is systemic discrimination, and I'm going to make sure everyone knows about it. Within 48 hours, I had contacted every attorney named in those complaints. 8 of them agreed to participate in a joint action. All of them Black or Latino, all of them with similar stories, stopped while preparing for hearings, questioned about their credentials, told they didn't look like attorneys, accused of being in restricted areas when they were exactly where they were supposed to be. Should courthouse security officers face termination after multiple documented profiling complaints? Let me know what you think. The story broke 3 days later. Local news picked it up first. Chicago attorneys allege racial profiling by courthouse security officer, then the legal blogs, then the national outlets. The Cook County Bar Association issued a statement condemning the pattern of discrimination. The NAACP called for an investigation. The ACLU offered to assist with litigation. Officer Derek Miller was placed on administrative leave within a week. The court administration tried to contain the damage, but the evidence was overwhelming. 19 complaints, 18 involving attorneys of color, all dismissed without meaningful investigation. The pattern was undeniable. Miller was terminated 4 weeks after the incident. The termination letter was direct and damning. Officer Miller engaged in a pattern of racial profiling against attorneys of color over a 10-year period. He repeatedly questioned the credentials and presence of Black and Latino attorneys while performing their professional duties. He created a hostile and discriminatory environment. His actions violated court policy, civil rights protections, and professional standards. His employment is terminated immediately. He is prohibited from working in courthouse security in any jurisdiction. Miller's union initially supported him, but once the full complaint record became public, they quietly withdrew. He issued a brief statement through an attorney. "I never intended to discriminate against anyone. I was trying to maintain security. If my actions were perceived as biased, I apologize." My response was public and unforgiving. "This wasn't perception. This was action. You stopped me and 18 other attorneys of color over 10 years. You questioned our credentials while white attorneys moved freely. You created an environment where we had to prove we belonged in our own workplace. That's not security. That's racism with a badge." The lawsuit came 6 weeks later. 8 plaintiffs, me, Marcus Thorne, and 7 other attorneys. The claims were comprehensive racial profiling and discrimination, violation of civil rights under federal and state law, hostile work environment, interference with the practice of law, intentional infliction of emotional distress, negligent supervision by court administration. The defendant was Cook County and the court administration. The evidence was devastating. 19 complaints over 10 years. 18 involving attorneys of color, all dismissed without investigation. Miller's own words on security footage in several incidents revealing his bias. Testimony from the 8 plaintiffs about the impact on their ability to practice law effectively. The county settled within 5 months. $4.5 million divided among the 8 plaintiffs. I received $650,000. I donated a portion to the legal aid organizations serving communities of color on the south and west sides. The court administration implemented comprehensive reforms, mandatory bias training for all courthouse security personnel, a zero-tolerance policy for profiling complaints, an independent review board to investigate discrimination allegations, random audits of security stops to identify patterns, and a formal apology to the attorneys who had been profiled. I testified at a city council hearing about discrimination in the justice system. I didn't expect to become an advocate for this issue, I said, my voice measured but forceful. I was just trying to prepare for a hearing. I was doing my job. But Officer Miller saw a black man with files and assumed I was a threat, a trespasser. Anything but what I actually was, a licensed attorney preparing to argue before a judge. I paused, looking at the council members. I had credentials, I had a bar card, my name was on the court calendar, and I still got stopped. So imagine what happens to black defendants who walk into that courthouse. If the officers can't believe a black attorney belongs there, how do they treat black people accused of crimes? How does that bias shape every interaction in that building? The room was silent. I practiced law for 14 years before that morning. I'd appeared in that courthouse hundreds of times, but that was the day I realized that no amount of credentials would protect me from someone's assumptions. No amount of professional achievement would change the fact that some people see my skin color before they see anything else. I continued my criminal defense practice, but I also became an advocate. I spoke at law schools about bias in the legal system. I trained young attorneys of color on how to document and report profiling. I pushed for reforms at the State Bar Association. I testified before legislative committees about the need for accountability in courthouse security. The video footage from the courthouse cameras became required viewing in legal profession courses. My calm dismantling of Miller's assumptions became a teaching moment about professionalism under pressure. My documentation of the pattern became a model for how to build a discrimination case. But my message never changed. This isn't about me having credentials. This is about a system that allowed a security officer to profile attorneys for 10 years without consequence. This is about bias so normalized that questioning a black attorney's right to be in a courthouse felt like reasonable security. This is about assumptions that operate below policy but shape who gets treated with dignity and who has to prove they belong. Officer Miller's career is over. That's consequence. The county paid $4.5 million. That's accountability. But money and terminations don't change the fact that 18 attorneys were profiled while doing their jobs. They don't erase the countless moments when we had to prove ourselves to someone who'd already decided we didn't belong. They don't address the stress of wondering every time you walk into a courthouse whether you'll be stopped, questioned, treated like a suspect instead of an officer of the court. The real question is what changes now? Do court administrators finally take complaints seriously after 1 instead of 19? Do they finally accept that security can't be an excuse for profiling? Do they finally understand that every person in a courthouse, from judges to defendants, deserves to be treated without bias? Because if we don't fix the systems that allowed Derek Miller to profile attorneys for 10 years, if we don't address the assumptions that teach people a black man with case files must be doing something wrong, if we don't hold institutions accountable for the discrimination that happens in their buildings, then we're just waiting for the next officer, the next attorney, the next pattern that takes years and multiple victims to expose. Comment below if you think one documented profiling incident should trigger immediate investigation and potential termination. And if you believe stories like this need to be told, if you think accountability matters and systemic change starts with exposure, then hit that subscribe button, because we're going to keep sharing these stories. We're going to keep demanding better. We're going to keep fighting for a world where a defense attorney can prepare for a hearing without being told he doesn't look like he belongs. This isn't just about one security officer or one attorney.